glitch. I couldn't reach out to you. Now, as I suggested, this webinar is going to be about two laws, one of which is the recovery of debts due to banks and financial institutions. Now, the intention of passing this act was very simple. The banks and financial institutions were facing considerable difficulties in recovering loans and were unable to enforce securities that were with them, such as properties were hypothecated or charge or any sort of a charge was created for them. And a significant amount would get blocked. And the values of these properties would deteriorate with passage of time and there was no recovery. So there was a committee on the financial system headed by Narasimhan, and it had considered in establishing special tribunals under these acts, after which Sri T. Tiwari, another committee, was set up in 1981 to handle the recovery of debts due to the government and to the banks of the government, the PSUs basically. So the committee at that time, on 30th September 1990, said that more than 15 lakh cases were pending in public sector banks and about 304 cases were with the private banks. What is astonishing today at that time is that when this law was passed, a rupees 5,622 crore was due to the public sector bank and rupees 391 crore was due to the financial institutions. Now the humorous side of it is that alone Vijay Mallya and people like Nirav Modi have loans running into thousands of crores. To be exact, Vijay Mallya is around 13 and Nirav Modi is around 11. And it is astonishing that when the act was passed, the whole debt of the nation was rupees 5,622 crores as far as public sector banks are concerned. So as I told you, the committee that was set up under the chairmanship of T. Tiwari had examined the legal and other difficulties faced by the banks. And the facts are mentioned here. Whereon on 30th September 1990, more than 15 lakhs cases were pending before the public sector banks and 304 cases against the financial institutions. When was this act passed? This act was passed on the 27th August 1993. What is the composition of DRT? So DRT is a special code and it comprises of certain people who are qualified to a certain level to function, and which is why the act mandates that there be a presiding officer, a recovery officer, and a registrar. What is the role of a presiding officer? The role of a presiding officer is to manage the whole case brought before it. And how does he do that? He does that by taking power and extracting power from these sections provided in the act. So firstly, there's a filtration process. A PO can only be appointed by the central government, and the central government may also authorize any other PO or judicial member of a DRT other than DRT to discharge the functions of a PO of DRT. And the person who is appointed as a PO must be a district judge, and then only can he be appointed as a PO. The tenure for which he holds the office is 5 years and he retires at the age of attaining 65 years. Now, a recovery officer. In order for you to understand what is a recovery officer is an officer that looks after the case after an order or a recovery certificate has been issued by the PO. Once the presiding officer decides the case, say a claim is brought before the presiding officer under an original application, as I had discussed earlier, and it is decided in favor of the bank that the bank needs to be paid 10 crore rupees from Mr. XYZ. So recovery officer is the person who will help in the superintendence, in the overall functioning and the execution of the recovery certificate. So the central government is the government that appoints one or more ROs, and ROs discharge functions under general superintendence of the PO. Primary duty of the RO is to execute the recovery certificate issued by the PO after hearing of the original application. No objection to the recovery certificate can be placed before the RO. What this means is that these are two separate independent procedural adjudications under the law. So the PO decides the amount due to the banks, and the PO is the only person who issues the recovery certificate. The only job of the recovery officer is to make sure that the amount recovered, amount mentioned in that certificate is recovered through the various powers given to it. What is a registrar's job at the DRT? A registrar's job is limited. He helps in the overall completion of pleadings and the appreciation of evidence and the procedure as close as can be followed to the CPC. Although you may be informed that the DRT is not obligated to follow a civil procedure code in toto, but in the light and equity of it, it does have a registrar, just like other civil courts, that helps in the functioning of the DRT, such as appreciation of evidence, conducting of cross-examination, to receive all documents and applications, and to ensure the compliance of it, just like a normal registrar does. So what is the qualification of a registrar in this case? A registrar has to be appointed by the central government. A registrar is the custodian of records as well as the seal of the DRT. Seal of the DRT is held with the registrar, can be used upon specific directions of the PO. He has the authority to receive all documents as explained to you and will examine them and same conform to the rules and regulations of the DRT. So DRT also has a very strong functioning, you will see. Apart from the RDDB FI Act, there is an RDDB FI rules that generally takes care of all of this. So what is the jurisdiction, the bar of DRT? A DRT can only take up cases which are 10 lakhs and above. According to Rule 6 of the rules, original application to be filed by the applicant with registrar within those jurisdictions. So say a bank, the jurisdiction of DRT is restricted to the appellant functioning of a bank and a financial institution for the time being. It can be filed where the borrower or more borrowers at the time of making application actually or voluntarily resides or carries out business or personally works for gain, and any borrower where there are more than one at the time of making an application actually or voluntarily resides. Basically, this is setting out this jurisdiction where the cause of action arises in part or in whole. And what is the pecuniary jurisdiction? I explained to you, it is 10 lakhs and above, and in some cases 1 lakh. So the procedure generally followed by before the DRT is as such. An original application is filed. Now, the original application is a very important and the most important application under the Act. In this, everything is covered in the documents to accompany along with the OA, and there's a format provided in the Act, and there are certain reliefs you can ask from the bank. So what is the form under which you have to apply it to the DRT. It is Memorandum of Appeal under Section 20, Section 30. It is Form 2. Proceedings. Hello, can you hear me? Applications under Section 19 of the RDDB and FIA due to banks and institutions can be filed in Form 1. So the original application has to be in a particular format which is mentioned in the Act itself, wherein everything from date of filing to the registration number of the bank to the details of the applicant, such as particulars of the applicant is mentioned, his address, his registered address, his address for service, and then the particulars of the defendant is mentioned. Then the limitation is set out in it, and then the most important, the facts of the case. After which the format also mandates you to ask your relief before the court. The relief sought can either be interim or permanent, and then along with it you have to give particulars of bank, draft, postal order in respect of the application fee, such as the court fee. So these are certain rules. An application can be made under 19 of the Act. The OA shall be presented in 2 sets in paper book along with empty size file envelope bearing full addresses of the borrower, guarantor, corporate guarantor. If the number of borrowers are more than 1, then sufficient number of extra paper books together with empty file envelopes bearing full addresses each of the borrower shall be furnished by the applicant. Every OA shall be accompanied by true copies of the document on which the applicant relies. A copy of the OA and the paper book shall be served on each of the borrower as soon as they are filed by registered post. Now, these are the certain documents that are to be accompanied alongside with this OA. OA is basically establishing your claim. So a bank files an OA, and for a bank to show that a debt is due, it shall disclose all details of the case and the decisions it sought to be reviewed. It has to comply with the accounts duly certified by the banker's book evidence, and all best evidence should be put forward. So OA is a very craftily drafted petition by the banks or the financial institutions, where a suit is presented through a legal practitioner or through a person from the bank for recovery of debts. What are the reliefs that a bank can get? This is the most important part in both, under which each of the loan facility would file OA before DRT seeking the following reliefs. It can ask for a joint or several decree and a recovery certificate in favor of the banks or financial institution and against the borrowers for the amount due. And please note that this amount due can be alongside cost, future interest and other charges at the contractual rates on the footing of the compound interest till the final realization. It can secondly ask for an auction of the sale of secured assets. Now, by sale of secured assets can be your movable assets, your cash flow properties. It could be anything that can help in the realization and satisfaction of the decreed amount. Recovered from other assets of the guarantor and corporate guarantor under the corporate guarantee. So if anybody were taken by the borrower, ask for a relief from the banks, from the DRT, that this guarantor's property also be attached for a successful and uh, total recovery of the amount. And in case, say that the debts are not fully recovered by either of the procedure, the applicant may also claim sale of the property of the borrower, whether tangible, intangible, movable, or immovable. And mind you, me, they come after the house at one given point of time, in spite of the existence of several Supreme Court decisions that the house is the last to be targeted. But sometimes the circumstances, and mostly the circumstances, are in such a case where a borrower generally owes the business premise for which he had taken the loan, and the second property existing will be his house. As discussed, the interim reliefs are something a little different from the reliefs he can ask in total. The interim relief can be that the banks and can request the OA to furnish a security for an amount equivalent to the due amount. As and when the borrower says that he is a bona fide borrower, he's a bona fide borrower. So generally what happened is one of the pleas taken by the banks is that the borrower or the guarantor equivalent amount of the amount due as restrain them disposing or creating any third party interest or asset secured under the transaction of the documents. It can also restrain secured creditors. So you see, these three aspects of these interim reliefs are so vast in nature that the banks can actually exercise the remaining liquidity you have left with you in case their dues are not paid. It can make a request to the court that all of your money be stopped from going anywhere else except to the secured creditor. Pass an ex parte ad interim order to file comprehensive affidavits of their assets both in India as well as in foreign countries along with documentary evidence. Now, this is a very extensive power that the DRT has. DRT can actually enforce a person to give a sworn affidavit disclosing the amounts of assets he has abroad. So you see that this act is not just limited to recovery in India. It can actually go and recover any of your bank lockers, vehicles, fixed deposits, demat accounts, mutual funds, shares, hypothecated policies, machinery, spare parts, consumables, whatever you have under the share capital of your company, even in abroad. It can direct the borrower to disclose a list of PI and receivables due to it from third parties and such parties to deposit or attract receivables with court or route it directly to the applicant or any other account as may be directed by the Honorable DRT. So you see, everything that the law can mandate for a recovery, which is legitimate, which can be within the constitutional aspect of it, the banks have been given power to reach every loophole and try and recover your money. So these days people think they are smart. I must inform them that the regime has made the banks much smarter than them. And they can always get a portion of or a whole of the property attached, which is not a part of your mortgage deed, because the bank's recovery of money is the utmost priority when it comes to public money. So what is the process? A process is I file a simple application before the court. The court grants a 30-day summon period, after which the summons are served and the borrower is held accountable thereon that he should not. The OA says that these are the properties, these are the third parties that you are supposed to dispose of, and you may file a reply. So within 30 days, he is summoned and he's mandated to file a reply to it. And the written statement period may be extended by a period of 15 days if the PO permits it. Once the pleadings are complete, it is followed by evidence by way of affidavit, wherein both parties are subjected to admission and denial. The amount that is admitted by the borrower is immediately decided, and the amount that is contested, that follows the process of evidence, which is not as strict as the civil court, but the PO may grant a permission for cross examination in case he feels the need to. After the hearing of the final arguments based on the documents presented before the court, through the duly process as has been showed here, the court is mandated to file a and finalize a recovery certificate within a period of 30 days. Now, this section is around section 19 of the Act, which is one of the most imperative section of this Act. Now, what is the proceedings after that? Say that a recovery certificate has been issued under section 1922, subclause 22. The amount in that is to be recovered. Who helps in recovery of that amount? As I had pointed out, the Act contained and who is the recovery officer? Somebody who helps in the execution action of the recovery certificate. So what he does, he sees the recovery certificates and the properties attached to it. Slowly and steadily, he starts taking all of the possession of the property in which the security interest lies, and he takes it by several ways. First, he issues summons to the person forward, present all of the securities he has lying with him that can successfully satisfy the debt of the bank. After the debt of the bank is satisfied, after the list is presented to the recovery officer comes out with a valuation of the property of the list presented to him and successfully conducts a sale auction for him for the said properties and tries and recover the money. Now, what needs to be noticed is that the amount of the recovery certificate can not be challenged before the RO. So RO is a step parallel to the functioning of the PO. It is not a step that mandates that you go into an appeal. Sorry, that is not the case. So, and recovery officer is somebody who will just ensure, like in an execution proceeding before the civil court, a tehsildar or a police officer or anybody is appointed. Out here, the law has already appointed a recovery officer who shall assist and take all objections on the ground of attachment of the property and ensure that he may investigate a claim made on the property, and any person aggrieved by the order of the RO may go to the PO again. So say I have a property X and I have the right to sell it. I'm an RO. The recovery officer has presented as a third party claim. Now, of which one cannot be decided by the RO. So he can be aggrieved by the order of the RO. So what will that aggrieved person do? He can file an appeal under section 17 of the Securitization Act and then approach the presiding officer of the party. As I explained to you above, section 20 deals with appeals. An appeal from the DRT has to be filed within a period of 30 days. An appeal can be filed once the borrower deposits 50% of the debts due before the DRT, and that amount can be reduced to 25% of the debt due seeing that the DRAT finds sufficient cause in doing such things. There are two landmark cases that had been decided, one of which is Supreme Court, decided by Supreme Court in the case of Axis Bank versus SBS Organic Private Limited, where it held that appeal before DRT can be entertained only if borrower deposits 50% of the amount in terms of the order passed by the Debt Recovery Tribunal, or 50% of the amount due from borrowers as claimed by the secured creditor, whichever is less. The DRT may reduce the amount to 25%. In another case, the Supreme Court held, this is the Deluxe Cotton Corporation and Bank of Baroda case, where it held that an application for condonation of delay can be filed. Therefore, Section 21 of the Act would apply even at the stage of consideration of the application for condonation of delay in accompanying the appeal under Section 20. So all the time, one thing that has been mandated by the courts is the deposit of 50% of the amounts mentioned in the recovery certificate. Then only will your appeal be entertained. Now, how much time has the appeal to be decided in? The appeal has to be decided in within a period of 6 months. Okay, we are done with the RDDB FI. Let me briefly sum RDDB FI up. Hello, everybody. So right now we went through RDDB and FI Act of 1993. As we have seen, the Act involves recovery of amount due to banks through a process specially drafted for the banks, crafted in such a way where the banks can easily avail this legislation and then try and recover their money as fast as possible. But being a practicing lawyer, what I need to inform you is that this 180 days that is mandated under the Act is not being complied because the DRTs have been heavily loaded. And then in 2002, there was a need felt by banks and the banking community and the RBI to pass a new legislation wherein all of this process could be avoided and a parallel process could begin, wherein somebody like a bank would just, without the permission of the bank, without the permission of the court, house and take control of the secured asset. Because all of this process that I just explained to you, the filing of the OA, the evidence, the written statement, after which the recovery certificate is issued, and then the again proceedings of the recovery officer, was taking a lot of time. So there was a need felt to pass the Securitization Act. What is Sarfeasi Act? Sarfeasi Act is the securitization. Sarfeasi stands for Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. Now this act talks about 2-3 aspects, one of which we are going to discuss here is how a bank and a financial institution can both, after the debts are acknowledged as per their book of accounts, come after the secured asset and take control of it without the involvement of the tribunal. RDDB FI was with the involvement of the tribunal. Sarfeasi is without the involvement of the tribunal or any court. And of course, the same conditions apply. The property needs to be 10 lakh and above. So Sarfeasi Act is basically talking about 2 sections where two aspects. One of which is a dealing between banks and financial institutions and securitization companies, wherein they deal and how they are allowed to, how securitization company can obtain their licenses, how they can overtake the security assets of the bank through an assignment agreement, and how all of that is given a legal validity under this law. That is the aspect we are not going to discuss in this webinar, because this webinar is primarily focusing on the legislative objective of these acts. So as much as that is also a part of the legislative objective, but the major crux of the passing of 2002 revolves around the failure of RDDB FI 1993. Not as much as a word failure, I would not like to be harsh, but to say give it a push, the Sarfeasi Act of 2002 was passed. Now, as I told you, in 1991, there were certain changes and legal framework of securitization that the 1993 the Parliament had passed the RDDB FI Act. However, that time there was another law existing. It was called SICA, Sikh Industrial Companies Act. And Sikh Industrial Companies Act was availed by all the companies trying to abscond recovery or payment of debts due to these banks. So there was a section in SICA, it was section 22, whereby the Board for Industrial and Financial Reconstruction, that was called BIFR, which was created under that act, mandated that all other proceedings be stayed once a company is declared sick. And once a reference was registered by more than 75%, only then could banks recover their money before the DRT. Whereas in all other cases, there was utter failure of 1993. It will be very pleased to inform you that this act that crippled and sort of questioned the viability of the strength of 1993 has now been repealed, and it has been repealed this December 2016, and a new act has been passed. It is called the Insolvency and Bankruptcy Code 2016. So, as I had informed you that there are two aspects in the Securitization Act, and the ones we are going to discuss in the current webinar is the enforcement of security interest part of it. So Securitization Act 2002, what it actually does, it empowers the bank to issue a 13-2 notice. Now, what is a 13-2 notice? A 13-2 notice is when a bank issues to the borrower telling him that your account has turned into an NPA. NPA is when the amount due to the banks has not been paid for a period of 90 days. So every loan that is taken has an EMI through an ECS process or through a bank collecting checks. But once 3 regular months, that is a period of 90 days, a bank does not receive its money. That's when the bank issues you a 13-2 notice. Under the 13-2 notice, what the bank expects from its creditors is that the banks that the borrower comes forward within a period of 60 days and repays the debt. But as in most cases, what happens is that the borrowers never show up. So the banks are enforced to take action under 13.4. Now 13.4 is also a very good section in terms of recovery of amount due to the banks, because it empowers banks with the expansive legislative power to go and recover money. And a lot of victims in India are a lot of borrowers are facing the wrath of the banks under 13.4. But there is a little respite that has been offered under the Sarfeasi Act is under section 70. Any person aggrieved is how the section begins. So by stating that any person aggrieved could be a borrower, could be a third party, could be anybody, he or she could go to under that application before the DRT again and file his objections and state out points where the bank has not complied with the regulations mandated in these two acts. Once that is established, there's always a provision for counterclaim. And But that is a very um, like practically that never happens. In a couple of cases, it surely has, but if you have to consider the ratio, the 97 to 3% would be my assessment of that ratio, where a borrower has been successfully able to establish that the bank has been at fault. So now coming on to the second part of the act, as we have talked about in our first session, in the first part of a session, is how 1993 was drafted for the purpose of recovery and how it failed. Luckily, Sika is no more. Sika was a big factor that had literally crippled 1993, and now it has been repealed. So, with the repealment of Sika and the strengthening of Sarfeasi again and again through various amendments, we are back at a position where banks are able to recover their money and the public at large can feel secure. So now I'm going to share my slide on the Sarfeasi aspect of it. So let's have a look at the slide. The Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. Now, under this act, there are certain questions that we may ask. Who is a borrower? Who is an who is a borrower as per this act? What is an asset reconstruction? What is an NPA? And what is a security agreement? What is a 13.2 notice? What are the measures that may be taken under 13.4? And questions such as what happens once the bank recovers money and there is excess amount left in it? So I'm going to briefly run you through all these questions and quickly finish off with my webinar, which has far exceeded the time I was allotted. So I had given you an introduction and I had briefly explained to you how the banking sector had faced certain reforms and how for the larger economic reform of the country, there were certain tribunals that were set up, one of which was DRT. Now DRT was mandated with another task in 2002 was the enforcement of security interest. Now how BIFER was abolished and how Securitization Act had come into play. So in this, I had already explained to you in the earlier part of it, what is an appellate tribunal, and we'll come on to the other important definitions. So coming on to the NPA part of it, what is a non-performing asset? Non-performing asset means an asset on account of a borrower which has been classified by banks or institution as substandard. Secondly, doubtful or loss of asset. In case of such bank and financial institution is administered and regulated by any authority or body establishment constituted or appointment by law for the time being in force in accordance with the directions and guidelines relating to asset classification issued by the authority or body. So this authority and body is the Reserve Bank. Reserve Bank has said that once an amount that is due to banks is not paid under the EMI scheme for 90 days, it can be classified as a NPA. And what is a borrower? Borrower, by the definition, would mean somebody who has been granted financial assistance by a bank, who has given any guarantee or created any mortgage or pledge or security of financial assistance granted by any bank or financial institution, and includes a person who has become a borrower of an asset reconstruction company consequent upon acquisition by it of any rights or interest of any bank or financial institution in relation to such financial assistance. So, as I had explained to you, this Securitization Act has two aspects to it. One of which is when a financial institution, one of the India's most premier and leading financial institutions, and asset reconstruction companies, to be specific, was RCIL. RCIL, it acquires non-performing accounts from banks and helps them recover on a certain basis of security agreement that has certain terms and conditions. So the asset reconstruction company goes to a bank and says, let me take over your account and I will do the job of recovery for you. For those recovery, I will enter into an agreement with you on the basis of certain terms and conditions. That is a very vast aspect, very corporate aspect, which we will discuss sometime later. But coming on to the major part of why this Securitization Act was passed is because the secured debt required a security enforcement against the debt. What is security interest, you must ask? Security interest means right, title, or interest of any kind other than those specified in Section 31 upon property created in favor of the secured creditor. It includes any mortgage, charge, hypothecation, assignment of any right, title or interest of any kind on tangible assets retained by secured creditor as an owner of the property given or hire of financial lease, conditional sale, or any other contract which secures the obligation to pay for an unpaid portion of the purchase price of the asset or obligation incurred or credit provided to enable borrower to acquire tangible asset or such right title in any intangible asset. License of such tangible assets secures the obligation to pay unpaid portion of the price paid of the intangible asset or obligation incurred or any credit provided to enable the borrower to acquire intangible asset or license of intangible asset. Basically, security interest is something that a bank can hypothecate, charge, or create a mortgage against. Now, before we discuss the cases of the security interest, I would like to discuss certain aspects and certain laws that are under the Sarfeasi that one needs to understand. Hello everyone. So this act that we have talked about and discussed so far, I'll quickly sum it up as I have far exceeded the time of the webinar. What is securitization has been defined under this act. What is a security agreement has been defined under this act. And those are the two aspects I will come up and deal with later. The major crux of this act is regarding enforcement of security interest and recovery of money. So first we have to understand on what sort of an account can an enforcement take place. An enforcement can take place on an account that has turned into an NPA. NPA is nothing but a substandard, doubtful, or a loss asset which the bank is unable to recover. After the classification of the account as NPA, what should be done? What is done by the banks is a 13-2 notice is issued. Okay, on the issuance of 13-2 notice, the law says that the borrower may reply to it and raise his objections under section 13.3. He is required to raise these objections and the bank thereafter is required within a period of 15 days. Now this 15 days period is not mandatorily required to be complied by the bank, specifically to the words mentioned in the act. They can later also respond to it. There are Supreme Court's judgments that saying if a bank responds to the objections raised by the borrower under 13(3)(a), it can be replied after a period of 15 days. But it is in the legislative intent that the Parliament thought that the bank has a duty to reply it within 15 days. So, hence, no case so far has been maintainable. Every time a borrower has come and raised a finger against the bank for non-compliant of 13(3)(a), the courts have held a very liberal view, and they have said that the banks are obligated, but still it is not mandatory and it cannot affect the merits of the case. So say that after this 13 notice and the 13 reply and the objections being denied by the bank, what happens? The bank can proceed under 13(4). 13(4) it can take certain measures against your properties. One of which is it can take possession of the secured asset. It can also take possession of the business that you're carrying out. But it is certain conditions under which the business can be taken control of. The control of the business can be taken over only when a substantial part of the business of the borrower is held as a liability, and it can only be taken under certain supervision that are provided in the act. So yes, the bank can, apart from taking away your property, secured asset, can take away your business also. Now there is a section, what happens if the bank recovers after selling off that property? What happens to the residual amount? The residual amount will first be required to cleared to the secured creditors. After that, any which amount that is remaining will come back to the borrower itself. Now coming at the important aspect to it, that is 1310. It says recovery of balance of amount due when the amount through the sale proceeds are not able to satisfy the amount. So if you will see, the current practice is such that once an application is filed under section 19 of section 19 of the RDDB FI Act, they automatically, the banks have started invoking section 1310. Section 1310 simply says recovery of balance amount when the amount through the sale proceeds are not able to satisfy the amount due. So see, hypothetically considering a situation where a property is worth 5 crores and the amount due is 14 crores. So the bank automatically knows before filing of the OA that even after selling this secured asset, they will not be able to recover the whole amount. So what the bank does is it files a joint application under 1310. And many a times this tribunals have held 1310 to be maintainable. Okay, now coming on to the most important part of this legislation is section 17. Section 17, I'm sorry, let me just skip to section 14. Section 14, as I had mentioned, is after 13(4), what the bank does is it goes into a conspicuous place of the property and sticks the notice. So that, say, it sticks the notice on the door, and it will also stick alongside the publication advertisement in the new vernacular language and the sale proclamation intimating to the other borrower and the guarantor that their property is going to be auctioned and sold. Now, what can a person do when such actions are being taken by a bank? So far in my webinar, I've been talking in favor of the bank, but now I will speak on what a borrower can do. A borrower, if he's aggrieved by any steps taken under 13(4), he may invoke within 45 days of such steps being taken before the DRT under Section 17 of the Sarfeasi Act. And he should well establish that under Section 17(3) that the banks have been at default and which may lead to a restoration of his property that the bank had let out for public sale or auction. Now, what the interesting aspect of Section 17 is that 17th section was supposed to be decided within a period of 180 days as well. No, I'm sorry, I take my words back. Section 17 was to be expedited within a period of 60 days, but as we see, that has not been this case. So a borrower has rights in case he feels that the bank has done something that is ultra wires its capacity to do. Say that it has sometimes what bank does is it takes bonds and securities receipts much before the loan has ever been sanctioned and then uses those documents at the time of recovery. That's when the borrower can establish that bank has conducted itself in a mala fide manner, and how he can avail that facility or that opportunity to show the court that the bank has acted contrary to the laws mandated under these acts is by approaching them in under Section 17. Section 17 is an application that has to be filed within 45 days of the banks taking any measures as defined in Section 13(4), such as taking possession of the property, such as taking possession of the banks, or sticking any of the news clippings or pasting any of the summons outside your property, or a sale proclamation notice. Now we talk about appeals. Section 18 of the Sarfeasi Act talks about appeals, and the same conditions as there are mentioned in the RDDB FI, that in case you want to apply to an appeal, you got to deposit 50%, which may be reduced by the courts to 25. Now both of these acts have rules to it. The RDDB FI Act has RDDB FI rules. The Sarfeasi has security enforcement rules. Now, security enforcement rules is basically setting out the certain steps for the banks to take, and in case the banks does not comply to that, it has defaulted in something that an aggrieved person can take action under Section 17. So say a bank issues a notice to you, and it's a sale proclamation notice, and the notice has been issued on the 1st of January. The bank is obligated not to conduct the auction until 31st or the 1st of February. But the bank goes and conducts an auction on the 26th of January. Then the bank has defaulted in compliance to the security rules that are mentioned in the Security Enforcement Rules 2002. And thus, you can invoke a Section 17 application before the DRT. As such, there are these laws, and this is a very vast sphere. So I'm going to close for today, and I hope this session has been interactive in the perspective of a mortgager, mortgagee, borrower, and bank. And if you have any queries or any specific questions, please feel free to write to me. My email ID is vipur@khurana.com, and I look forward to interactive sessions and detailed query coming from the viewers. Thank you so much. Thank you again.